Shall we kick off then with the panel session? So we had a quick chat yesterday between the three of us to discuss what we wanted to get out of the panel session. And while Adrian's provided an overview of the legislation, I think I described it as potentially dry yesterday. It wasn't at all. It was very interesting. So thank you very much for that. What we wanted to do in the panel session is focus on some of the practical, commercial and strategic objectives and implications of the new DIFC regime. And so it's obviously only been in for a matter of weeks now, so there's an element of crystal ball gazing, but we have a very experienced panel who'll be able to bring to bear their experience in other jurisdictions and in the DIFC in order to kind of help think about some of these issues in a little bit more detail. So I wanted to start with you, Adrian. We think about, it's very easy to sort of think about jurisdictions as debtor-friendly or creditor-friendly jurisdictions and to categorise them in quite a binary fashion. So I was just wondering what your view is on how the new DIFC regime affects the balance of different interests of the different stakeholders in a restructuring and insolvency scenario, and whether perhaps you think that any elements of the regime may bring more collaboration between those different stakeholder interests.
Sure. So I don't remember us discussing that question actually.
Sorry.
In the European context, we used to, not entirely seriously, we used to talk about the olive tree test, which is that those countries which feature olive trees tend to be debtor-friendly, and those jurisdictions which are unable to sustain olive trees tend to be much more creditor-friendly, which of course is a way of saying that the UK and those countries in Northern Europe tend to be much more sceptical of debtors, and then as you go down into Southern Europe, there's much more greater concern about the debtor and employees and jobs, for example. But I think those, and also there's a distinction until the United States introduced Chapter 11, there was very much a distinction between common law jurisdictions and civil law jurisdictions as well, with common law tending to be more creditor-friendly. But I think those distinctions are becoming quite anachronistic quite quickly because of the work that the World Bank and the European Union and others have been doing over time. I think that it's more a focus on preserving enterprise value, and so therefore there's a recognition of the importance of insolvency practitioners, but there's also a recognition that there are ways of doing things, if you want, with less sort of invasive surgery, that those who kind of know the business and run the business are often best placed to continue running the process so long as they're adequately supervised and that there are adequate safeguards for the creditors in doing that. I think the DIFC is very much in that zone of recognising that you don't want to just chuck the baby out with the bathwater as soon as you need to do restructuring. That if you can retain management, but couple with that they're getting proper advice and that they're properly supervised, and if the circumstances arise, it's no longer appropriate for them to remain in a sort of fiduciary position. That's a sort of ideal balance. And that's what I think the new DIFC legislation is trying to do. So I think it is trying to get that balance right. Of course, you can have the most excellent legislation, but there's also a thing called the law of unintended consequences, which is the DIFC law 2021 to come. I'm sure it's on Jacques' agenda for future legislation. And under the law of unintended consequences, clever people out there find ways of using things in ways which are not necessarily anticipated, or things evolve in a way, and that's the importance of market practice. And and time will tell how these things work. And it'll be interesting as a practical matter to see how things play out.
Presumably the idea of not chucking the baby out with the bathwater was in mind when the idea of the automatic moratorium in the context of rehabilitation procedure was was brought in, and it very much sort of allows people to give time, give breathing space. Yeah. To think about how things work. It brings in this new cramdown procedure for secured creditors under the rehabilitation regime. Do you think you'll see debtors and creditors working together to develop a restructuring solution using that regime?
No, I do. I think so. There's those that are mentioned in the presentation. There's the key requirement of the statement from the rehabilitation nominee. That the plan will be approved by the creditors, and obviously the debtor's in no position to judge that unless they've actually spoken, or be an unusual situation unless it's such an amazing deal that no one could possibly turn it down. That's unusual in a distressed context, but can happen. The only way you're really going to be able to address that is by speaking to key stakeholders to ensure that they are on side. What really this process should be is a collaboration between, on the one hand, the management of the company, and on the other hand, the key stakeholders to find a solution that is workable for them. And you're really only using the cramdown to deal with, as sometimes happens, people who are just leveraging off the distress in order to gain advantage over everybody else. So that's the point of the cramdown. The point of the cramdown is not to take advantage of people. Actually, the point of the cramdown is to stop other people taking. I should be a politician, shouldn't I? The point of the cramdown is to stop other people taking advantage of creditors and the stakeholders.
Okay, agreed. And what about DIP financing? You didn't talk about that in much detail. Do you think there's going to be a ready market for that? Do you think people are going to be willing to participate? Do you think it'll take time for people to get comfortable with the regime?
Yeah. So on that, I'd probably bow to people who are here in the DIFC and Dubai generally, who sort of know the market.
Well, I think an interesting point, because I was discussing this point with one of my US counterparts, and they have very active participation from investment banks to actually rescue and invest in these kind of things. And they would certainly be interested to look at these kind of markets, and we've been successful in looking at litigation funding. It's already happening, and me as an insolvency practitioner, I have some things which I'm also looking to get litigation funding. So it's already established. I think that DIFC has demonstrated, I've from my own personal experience, I mean the court process and the laws have been very clear and useful in doing a lot of the insolvencies I've dealt with. So certainly there is a confidence in this kind of market, and I think it's been demonstrated by some of the rulings by the justices. So I think and this framework will certainly add to that, because I think they've already set a benchmark in terms of how they deal with that. And as Jack said, that you had this special thing for Dubai World, which was quite successful, and they had some of the top judges actually ruling over those matters. So certainly Dubai has been at the forefront in developing those kind of resources.
Yeah, I think you sort of feel like it might take a while for people to get confidence, but with a comprehensive and coherent regime and the belief in the position of the DIFC generally, we should get there. So that's all very encouraging. Do you think, Shahab, then that the new regime will help develop more efficient procedures and ultimately drive better recoveries for creditors?
Well, I think that we've already seen that things we do in the DIFC, contrary to what happens in jurisdictions, and I think DIFC is unique because although we are in Dubai, we also have to deal with Dubai courts. So quite often people prefer to go to Dubai courts, and then they try to see how they can do it. But eventually they realize that the DIFC courts and the process, because many of the creditors actually registered outside the DIFC. The entity may be in the DIFC, and so therefore you have this cross-jurisdiction issue coming in. I don't know whether UNCITRAL will work on that, but certainly I think they come to realize that this is more efficient, and I think the new laws that they have enhanced that in terms of rehabilitation, in terms of administration, in terms of misconduct. So I think that will certainly add to the confidence, and I can see them specific things, and even from the insolvency process, that they have actually looked at property, how you deal with property, how you deal with leases, which helps, because we've had a lot of cases recently where there's always been a kind of tussle between the landlord and the property owners, and so it's kind of given some clarity. I think so certainly it will become better in dealing with those matters, and it will help at least the practitioners to rely on these kind of provisions.
Okay, great. And one of the other things that Adrian touched on was the elements of the regime that touched on dealing with poor management. So he talked about the enhancements to the wrongful trading regime and also the introduction of the new administration procedure in situations where creditors have not got confidence in management. So do you think that will be helpful? Do you think that will be utilised? Do you think that's an important aspect of the DIFC reforms?
So I think the existing laws had provisions to look at all these matters, and you could look at transactions at a preference and things like that, and it mirrors similar kind of processes they have globally. It's not, so I think they've taken that as a benchmark, but they certainly have enhanced it with this issue of putting more clarification on wrongful trading and what are the remedies, and this new clause for misconduct, that's also been actually introduced in this new law. So, and beyond that, I think even from the confidence building, the liquidators now have a bonding, or insolvency practitioners will have a bonding requirement, which will protect from any fraud that might happen in a liquidation. I mean, thus far we haven't had any kind of issues with that, but certainly I think it will build the confidence. They will, with any other law, as Adrian has said, that it will take time for people to understand and accept and assimilate the provisions, and there may be a lot of test cases. I mean, in our experience, although the law has been there, but there have been many test cases in the DIFC that have actually clarified the position of the law. So that will certainly happen as we go along. You know, in terms of, even if you look at Singapore, I was there recently, they have enacted the law on 1st September 2018, it's been in discussion, and they have a similar arrangement called judicial management, which forms pretty much the same thing. There's a lot of judicial oversight in terms of how you do it, but not many people have adopted it. They haven't any reported cases, and so it will take time for people to see how it will work, and especially in rehabilitation, you have to have a proper business plan. You can't, you won't be having many people coming to the fore. There'll be probably more insolvencies because it requires that extra bit to ensure that whatever you propose is viable. You can't just, so I think that they will be limited, but I'm sure the framework will assist that.
Yeah, I think that idea of precedent is very important. I think we were talking to an office holder once, and they said, we love precedent unless it's us who's creating it. So that it's always that who's going to jump first, but with a comprehensive regime behind it, I'm sure that will happen. Adrian, turning back to you then, one of the other things you talked about was the adoption of the UNCITRAL model law on cross-border recognition of insolvency proceedings. I think you described it as an audacious step in the introduction, which I think...
In a positive sense.
Absolutely, in a positive sense. I mean, I think it is a great development, particularly in this region where we're quite often grappling with issues about recognition. So I suppose the question is, do you think that will lead to enhanced comity between the GCC jurisdictions and also jurisdictions overseas?
I would like to think so. The adoption of the UNCITRAL model law is not universal. The United States, United Kingdom were both early adopters of the model law. But for example, even now, the majority of European countries haven't adopted it. But there's a large number of countries around the world which have. Within the GCC, the UAE federal law the jurisdiction hasn't adopted it. But the Kingdom of Saudi Arabia, as part of its new legislation, has, although it hasn't yet implemented it. So that's one of when I last checked, it's one of those pieces of the legislation that hadn't yet been brought in. So in terms of, if you're looking at the GCC as a whole, you really want all of the jurisdictions. You want a critical mass of jurisdictions that have adopted it. I think the more that do, the more that that leads to the critical mass, and I think that it enhances the standing of the DIFC in that it's saying we are open to comity. We are here to help to facilitate international restructurings, and of course, in many cases, there is an international component to an insolvency or a restructuring. So the greater the availability of comity between jurisdictions as a practical matter, the more likely you are to achieve a restructuring. So I think it's a good thing that the DIFC are doing it. It's in terms of reciprocity and recognition of DIFC decisions. In terms of the region, you've also got the UAE, you've got Dubai onshore, then you've got the UAE, and then you've got the wider GCC. As I understand it, again, I'm not a local, my local knowledge isn't sufficient to deal with this, but I understand so far as Dubai is concerned and onshore, there are mechanisms for recognition of DIFC judgments, and that does happen all the time. But it would be great if there was a greater reciprocity or receptiveness to comity within the region, given that so many businesses have interests across the different borders.
I mean, just on that sort of local colour, the Bahraini government introduced an insolvency law it became effective at the end of 2018, and that includes recognition procedures at the back. Right. So we've been talking a long time, I think, about the introduction of insolvency regimes and the desire to reform across the GCC. Yeah. And I suppose the point is that it's happening in different stages, and DIFC is very much at the forefront. And when you're talking about the regimes that happen, the developments that are happening in Europe at the moment, in many ways it's further ahead in some senses, and the other GCC countries are developing as well. But so maybe these sort of things that will, legislative reform doesn't happen in one step; it happens gradually. So maybe it's the sort of thing that we'll start to see when jurisdictions like the DIFC take leadership on that front.
There's been some sort of there's always been a concern about preserving the way things are done locally in the area of insolvency law. So when the European Union insolvency regulation came out back in 2002, that was a framework for recognition, but it very much left each country with the autonomy over its own insolvency laws. And the fact that we achieved the step in 2002 took about 20 years, and yet it was limited to recognition. It would be good to see the GCC reach that stage. The next stage, which is convergence of insolvency laws, which is what the EU is doing with its latest directive. That's a sort of, that in a funny sort of way in the GCC, things are happening in reverse. So there's a kind of, although the language is different, so you've got protective composition procedure under the UAE law, you've got financial restructuring procedure under the Saudi, and you've got rehabilitation here in the DIFC. Although the language and the process and the nuts and bolts reflect the different cultures and also the background of the corpus of law and traditions. Nevertheless, you can see as with Singapore, as with all these different jurisdictions, you can see underlying convergence. So you sort of the convergence is almost happening ahead of the recognition, which is kind of different to the way things have evolved in Europe. But that's, there were different ways of doing things, and you'd like to think that as there is a convergence and a kind of growing common culture in relation to rehabilitation, that should really make recognition easier, you would have thought, because you aren't dealing with such radically different
public policy considerations.
There should be less in the way of public policy differences. Yeah.
I want to ask Adrian a question as well. So I know Singapore has also accepted the UNCITRAL protocol, but what about, I think for of course DIFC is important because it's a financial center. It has a lot of dealings with, say, Singapore and Switzerland and maybe UK and the US. Now US, irrespective of UNCITRAL, has Chapter 15 that actually recognizes foreign jurisdictions. So that's specialist. But what about Switzerland? Do they have some kind of thing, because that's quite important for a lot of functions that happen, even when you look at financing or private clients or so many other elements that fall into this.
Yeah, I don't know for sure the answer to that off the top of my head, although I would wager that it doesn't. But because I don't think I think Switzerland's Switzerland's approach, I think, will be common with other Central European jurisdictions which don't, or very few, have adopted the UNCITRAL, and Switzerland in particular, I think, is unlikely to have, given its own culture. But I'm not 100% sure of that. I could probably Google it if you would give me a...
He's just offered a wager, so...
Gaming contracts...
Shahab, have you, this is probably a bit of an unfair question because of the amount of time that it's been enforced, but have you heard of any companies looking to utilise the new law? And I suppose, I appreciate that you may not have had anyone knocking at the door just yet in the last 2 weeks, but certainly we've been receiving a lot of questions from practitioners in the region about the implications of the law. So do you think there's a sort of groundswell of interest in terms of companies who may be facing distress at the moment as to what this might offer for them?
Well, I think it's early days in terms of for them to digest, and I think the law becomes effective 28th August, is that?
No, it's the employment law.
Oh, okay, so I got it.
The law is effective as it is.
Okay. So I think one of the lawyers sent me, I think that it is effective 28th August. So.
Yeah, they announced both laws, and I think the first announcement that came out in the media office, they confused the two dates.
Oh, okay.
The insolvency law is already enacted. The employment law is also enacted, but there's a 90-day grace period for employers in the DIFC to basically come in line. So the effective date of that law is the 28th of August.
But I think, well, if you take it from a historical perspective, when Chapter 11 was introduced, it took many years for people to really start using it. And so I think that the same process will happen here. And Singapore is the same, where they do have this process of judicial management, but there isn't any significant thing. So like I said, that notwithstanding that it's there, it will require, I think that DIC will probably have fewer cases purely from the size. Now, it may become a center for organizations to look at it, as you said, if there's convergence and agreement. So this could be a center because they have established court system, they are very good judges, and the laws are pretty clear to most of the stakeholders. So early days, very difficult to say. I mean, no one has come knocking at my door as yet, but
it's that precedent point that we talked about earlier, isn't it?
So Shahab and I will be outside afterwards, so if anyone's got any business for us.
Yeah, we've already made a pact that if anybody is interested, we can cut a deal.
Yeah, we're offering a special discount just today.
Yeah. Early bird discount.